Yes, friends, welcome back. We will discuss further about the incorporation of LLP and its related topics. As far as this session is concerned, I will be discussing upon the name part of LLP and its relevant details. Further, I will be discussing on the steps of incorporation of an LLP and lastly, partners and their relations. Of course, I beg my apologies in advance that these points are written in a very small font size. I do understand that, but to cover such a humongous topic, I need to, put it in a smaller font so that the videos are in continuity and helps you for better preparation. I can split the videos and do it, and it will be umpteen number of videos with 10 minutes, 15 minutes videos. Rather than that, I thought it's more convenient, though there is a small inconvenience of small font size, which I am again and again establishing that I am reading it for your benefit, so that you need not miss on the important points. So I hope you pardon me with your biggest possible heart and allow me to explain even though it is in a smaller font size. Yes, let's start. What are the relevant points as far as the name of an LLP is concerned? Let's see one by one. The usage of limited liability partnership, or its acronym called LLP, should always be suffixed, or it should always be at the end of the name of a particular entity. Let's say Loith & Co. Chartered Accountants is the firm or proprietorship firm that I have. What I can better do is, if it is an LLP, assuming I also have a partner, then I should definitely suggest, or rather write, or in all my collaterals, I should mention it as Loith & Co. LLP. Are you understanding? Or should I mention it as Loith & Co. Limited Liability Partnership? But popularly we see Loith & Co. LLP, that is Limited Liability Partnership, as an acronym used as a suffix to the entity's business name. So business name, its suffix or at the end of the business name should be the word LLP, or it should be the elaborated words called Limited Liability Partnership. Are we clear on the first point? Yes. Next, if the central government feels that the LLP's name is undesirable, or it is identical, or it is too nearly resembling of that of any other LLP, or of another body corporate, or of a registered trademark, or one who is applied for a registered trademark before the Trademarks Act 1999, then definitely registration is not possible, because it amounts to copying another person's name, whether with intention or without intention, it doesn't matter. Now I can't keep, let's say, Infosys Technologies LLP, because Infosys is already a registered company, it has its own trademark, it has its own brand. So if it was allowed, the brand and the reputation of Infosys is basically copied by me. That should not be the case. The reason, that is the intellectual property of another business, therefore it will be denied. Where if your LLP's name is basically what the central government feels, that if it is undesirable, or it is identical to another name, or it too much resembles to another name, or a body corporate or a LLP, or where there is already a registered trademark, or one who has applied for registration under the Trademarks Act 1999, definitely the registration is not possible. Therefore, I have mentioned no registration here. Moving further, if any person can apply, he should apply it in such form and pay such fees to the registrar for reservation of the name. The first thing is, he has to reserve a name to start off with. That reservation is known as proposed name of LLP. So the first starting point for registration of an incorporation of an LLP is basically to reserve a name of the LLP. What would you propose it? What would you like your LLP to be known as? So therefore, first point is you need to reserve the LLP. That means you need to apply. The registrar cross-verifies it whether it is in line with the provisions of LLP Act, or the central government can check whether it is undesirable or identical or it is too close to someone else. After all these formalities, the proposed name, that is the application for reservation of the name, takes place. Once the authorities are satisfied about it, that is, if all conditions are satisfied, then the registrar may reserve the name for 3 months. Mind it, for 3 months the name will be valid to be used by you. After 3 months, if you want to use the name again, you have to again apply with the same procedure. In the meantime, if somebody else has used the name, then you cannot use the name. That's the meaning of this 3 months point. So if all conditions are satisfied, then the registrar may reserve the name for 3 months from the date of intimation by the registrar. It is not from the date of intimation by you to the registrar. After all these thorough checking, the registrar will intimate to you that yes, the name is available for you and you can use it. That date of intimation, from that date, this name will be valid to be used by you for a period of 3 months and not thereafter. If you want to again use the same name after 3 months, you need to follow the same procedures what I have just explained in point 1, 2 and 3 above. Next point. If any name is already registered by way of inadvertence or otherwise, whether it is the original name or the changed name, then if the central government feels that it is undesirable or is identical, etc., then it may ask the LLP to change the name, and the LLP shall comply with the direction within 3 months or such longer period. What does this point mean? Suppose your LLP is already registered name, and if the central government feels that such name is undesirable for whatsoever reasons, maybe it is a national security threat, or it is not in the interest of the public, or for whatever reasons like identical nature to someone else's name, which was inadvertently or by mistakenly obtained, or it could be a case where the registrar by his negligence has allotted the name. For whatever reasons it could be, where there was already a name existing and yours is a later name, then definitely central government can take a call on cancellation of your name. That is, they will intimate you to change the name if such issues are found. Now, whether it should be immediately changed, no. The central government will give you 3 months time or such a longer period of time to change the name. You need to comply with such a direction. If you don't comply with such a direction, then we have the 6th point. 6th point says, if the LLP fails to comply with such direction, then there shall be a fine that will be levied on the LLP, which will be greater than 10,000 but lesser than 5 lakhs, and on the partners of the LLP, including the designated partners, that is, on the designated partners precisely, the fine shall be greater than 10,000 but it shall not exceed 1 lakh. So the point to be noted here is, even though you have reserved the name, even though you have started your business already, if the central government feels it is undesirable or identical or etc. things which I just discussed, then central government definitely has the right to ask you to change the name. Of course, an opportunity of being heard shall be given to establish the point that your name was the first name and the other person's name was the second name. That is only if it is identical or too closely resembles to something else. But if the central government feels that it is undesirable, or if it is a national threat, or if it is not in the interest of the public, then the question of this opportunity of being heard may not be given. I am not taking a stand that it will not be given. It may not be given because the central government is the sole authority to take or make rules and amend regulations as far as LLP Act 2008 is concerned. Therefore, this 3 months notice period or such other longer period has to be adhered to, failing which the LLP or the designated partners, the LLP and the designated partners have to pay a huge fine on it. That is, fine will be leviable, which is for the LLP it is greater than 10,000 but less than 5 lakhs, and for the designated partners it will be greater than 10,000 but less than 1 lakh rupees. I hope the relevant points regarding name of LLP is clear. This can come as a short note question if at all it comes to the exams. So please kindly note these 6 points which will be helpful for your exams. Yes, friends, let's move to the next topic, that is steps to incorporate an LLP. It's pretty simple and straightforward. Only 3 steps involved. How is it? Let's see what it is. First, as I've already mentioned you, a reservation of a name by filing form, that is E-form 1. You have to mention your name which you want your LLP to be called, that is proposed name, in which form E-form 1 has to be filed before the registrar. Again, it should be electronically. Remember that, do not forget that all these communications and documents should be in a computer readable form, that is electronic application. You should file E-form 1 mentioning your name for the purpose of reservation of the name. Once that happens, next file E-form 2 with the details of the proposed LLP business, partners, designated partners, their consent letters and other related documents in form E-form 2. That is, in E-form 2 you need to file these details. What are the details? I repeat again, the details of the proposed LLP business, then the partners details, then the designated partners details, including their consent. And lastly, you need to file your LLP agreement mandatorily in E-form 3 within a period of 30 days from the date of incorporation. That is, if your E-form 1 and E-form 2 is successful, incorporation certificate is granted to you by the registrar. Once incorporation certificate is granted, you need to file your partnership agreement before 30 days from the date of incorporation. E-form 1 and E-form 2 will also include incorporation documents, which I have already explained to you in the previous video. After all, once your incorporation certificate is obtained, within 30 days, you need to file your partnership agreement mandatorily in E-form 3. Are we clear with E-form 1, E-form 2 and E-form 3? Fantastic. Now last bit of this video, pretty elaborate I know, but it is similar to what we have already read in Partnership Act 1932. It should not take much time, though it is elaborate. In my opinion, this is a target question for exams. If at all there is a 5 marks question or 4 marks question when it eventually comes in the exams. Let's see what it is all about. Partners and their relations between them. Let's see. First point, persons who are subscribed their names in the incorporation document automatically become the partners of LLP. However, in case any other person wants to become a partner, if he adheres to, or if it is in accordance with the LLP agreement, then he or she can become a partner of LLP. So the first option is you subscribe your name to the incorporation document, then you are a partner of LLP. Or later on, if you want to be inducted as a partner into an LLP, it should be in accordance with the LLP agreement. That is absolutely clear. So 2 options. 1, straight when you apply for the name, or when you are lent your name as a partner to the LLP. 2, later on, admission of a partner in an LLP if it is in accordance with the LLP agreement. Are we clear on that? Yes. Next, mutual rights and duties of partners of the LLP, mutual rights and duties of the partners of the LLP, and the partners with the LLP is governed by the LLP agreement. Remember, I told you long back in the previous sessions that there is no mutual agency concept between the partners, but the partners are the agents of LLP. Binding nature between the partners is not there here. That is a unique feature of a LLP, because that itself leads to the concept of limited liability. So what do we understand here? Mutual rights and duties of partners of the LLP and partners with the LLP is governed by the partnership agreement. Sir, what if partnership agreement does not provide these details? Then remember my first session, we shall go and check the first schedule of LLP Act 2008 to derive these details. In the absence of any agreement between the partners of the LLP regarding these points, we go to the first schedule of LLP Act 2008. Moving further, LLP agreement and changes, if any, shall be filed with the registrar. These are bullet points, straightforward points. already an LLP agreement is there which is filed with the registrar, which has to be filed as already mentioned here. It is mandatory to file the LLP agreement within 30 days from the date of incorporation. And after filing the LLP agreement, in case there is any changes or amendments made to the LLP agreement, then such changes or amendments also needs to be filed with the registrar. Next point. LLP agreement in writing before incorporation may impose an obligation on the LLP, and therefore it can be ratified by all the partners after incorporation. What does this mean? Say, before incorporation, there were 3 partners who had LLP agreement written, and in that written agreement, if it states that post incorporation certain changes needs to be made, then in such scenario, after obtaining the incorporation, partnership agreement can be ratified. Ratified means changed or corrected by all partners involved in the LLP. It is not restricted to only the designated partners. All partners should consent, should ratify the change what was imposed prior to the incorporation by way of an earlier partnership agreement, and the revised or the ratified partnership agreement also needs to be filed with the registrar. Keep that in mind. Moving further, if a partner wants to resign, important point, if a partner wants to resign, then it should be in line with the partnership agreement, which means partnership agreement should provide for if and when a partner resigns, what are the procedures to be followed. If he wants to resign, then he needs to follow such procedures. So what if that procedures or clauses in the partnership agreement was not available, then definitely here is the point for you to understand it. If in the absence of which not less than 30 days notice should be given, that is, if the partnership agreement does not, rather LLP agreement does not have the details regarding a person who has to resign, what are the formalities he has to do. In case that details are not given, then 30 days, not less than 30 days notice has to be given by the person who wants to resign to the LLP, and thereafter the resignation takes place. Moving further, interesting points to be noted. A person can cease to be a partner of LLP. That means existing partner can be treated as ceased partner or retired partner or deceased partner. When can he cease to be a partner of the LLP? There are important points which is pretty common sense. That is, if he or she has deceased, died, or if the LLP itself is dissolution of LLP has happened, then if that particular person has been declared as an unsound mind, or if that particular person has applied to be termed as an insolvent, or applied to be adjudged as an insolvent, or is already declared as an insolvent, then such person ceases to be a partner of the LLP from the respective dates. Are we clear? When can a person cease to be a partner of LLP? Death, dissolution of LLP, he is applied to be adjudged as an insolvent, or is declared as an insolvent, or if he is of an unsound mind, then he can be it can be said that he has ceased to be a partner. His term as a partner ends there with the LLP. Are we clear on these points, my dear friends? Yes. Let's move further. Now, what is the capacity of this person who has been ceased to be a partner? I, in simple words, have kept it as former partner for your understanding. The former partner is still regarded as a partner of an LLP. He continues to be treated as a partner of an LLP unless the person dealing with LLP has no notice of his cessation. If a third person wants to deal with the LLP, he is not aware that if this partner has ceased to be a partner, then this so-called former partner, in his according to him, he continues to be a partner, and all the respective rights and obligations of the remaining partners continues to operate on this former partner as well. Or if no notice is delivered to the registrar of the fact that so-and-so partner has ceased to be a partner, I have mentioned it in simple words, not delivered a notice of cessation to the registrar. So there are two cases where he can be treated as a partner even though he is a former partner. One, the person who is dealing with the LLP is not having notice of his cessation of he retiring or dying or whatever it is. And second, if the cessation of a partner, its notice is not delivered to the registrar, obviously in the registrar, the ROC has not recorded this latest fact. Therefore, in terms of documentation, this so-called former partner continues to exist in the documents. Therefore, he can be treated as a partner even though cessation of a partner has happened here. Why is it important? The next point clearly answers it. Cessation does not discharge the former partner from obligations while he was a partner to the LLP or other partners or third persons. This is the critical point, my dear friends. If cessation has taken place, whether with notice or without notice, what is the important point we have to understand here is, if notice is given to the registrar or if the third person is aware of the cessation, then of course any acts done thereafter, this former partner is not under any obligations. However, if the notice was not given, or if the other person is not having a notice of this cessation, then along with other regular activities while he was as a partner before the cessation, all the obligations continues to be with him even though he is a former partner. That is very clearly mentioned here. Cessation does not discharge the former partner. He does not escape the obligations when the cessation takes place, because whatever obligation that was existing while he was a partner, that continues to be there on his head. So therefore, cessation does not discharge former partner from obligations while he was a partner to the LLP or to the other partner or to the third persons. I hope the point was very clear enough. Moving further, the former partner, unless provided otherwise in the agreement, is entitled to receive from the LLP. That means at the time of retirement or death or insolvency, what I have just mentioned, then he is entitled to receive from LLP what? First one, an amount of capital contribution of former partner actually made to the LLP. That is nothing but whatever credit balance is lying in his capital account and current account, he is entitled to get it back. This is in line with the Partnership Act 1932. The closing capital balance has to be repaid back to the partner. Similarly here, the actual capital contribution made by the former partner to the LLP shall be given back by the LLP to the former partner or his authorized legal representatives in the case of death. In addition to that, a right to receive a share in net accumulated profits, my dear friends. What is net accumulated profits? Accumulated profits minus accumulated losses, if any, of the previous years shall be netted off, and after netting it, if there is a positive accumulated profits, then he is entitled to receive such share from the LLP. That is right to his share in net accumulated profits as on the date of cessation as a partner. So as on the date of cessation of the partner, prepare the books of accounts, arrive at his capital balance, arrive at his current account balance, repay the balances mentioned in the capital account and current account, also work out the provisions, also work out the accumulated profits after adjusting the accumulated losses. If the net balance is positive, that is, if it is showing a credit balance, accumulated profits, that is, if it is showing accumulated profits credit balance, that credit balance, out of it, he has to obtain his share. Share is as decided in the partnership agreement, in absence of which we refer to first schedule as already mentioned, that should be given to the seized partner or his authorized legal representatives. Last point, very interesting to note, the former partner or a person entitled to his share upon the death or insolvency, basically his legal representatives, shall not have any right to interfere in the management of the LLP. Definitely, after the date of cessation, the former partner or his authorized representatives shall not have any rights whatsoever to participate in the management of the LLP. Now, this has something slightly against or slightly moving away from what we read in Partnership Act 1932, that is under Section 37. We happen to discuss that from the beginning of the financial year till the date of death, share of profits should be given to the deceased partner, that is to his executor. From the date of death till the end of the financial year, share of profits or 6% interest per annum, whichever is higher, shall be given to the executor. To arrive at such thing, the executor had a right to inspect the books of accounts and check whether the accounts were right. Now, the question is, in this case, the former partner, once he washes off his hands after receiving his capital contribution, current account contribution, if at all there was any, and share of net accumulated profits, there ends the journey. He or his authorized legal representative will not have any right to interfere in the management of the LLP. So these were the points, my dear friends, as far as partners and the relations is concerned. There are further provisions of LLP which I will be covering in the next sessions. Please do watch it. In case you have any doubts, please mail me to loyalacademy@gmail.com. I will revert back to you. Thank you so much.